Thank you very much. Again, just a real quick background. I've been doing HIPAA compliance consulting really since 2003 for all intents and purposes. That's back when the HIPAA security rule came out, which required regulations to secure electronic protected health information as well as health information in paper form and, of course, oral form. I've probably done over 1,000 risk analysis throughout my career for covered entities of all shapes and sizes, very large hospitals, small little medical practices, insurance plans, outpatient facilities, clearinghouses, pharmacies, essentially any group dealing with protected health information as a covered entity. I've also done hundreds of assessments for groups such as what we're talking about here, business associates, which I'm sure you guys are familiar with. Those are groups, ancillary groups, that are privy to protected health information to perform a job function on behalf of the covered entity. And just a little side note, there are roughly 7 million business associates in the United States versus around 700,000 covered entities. So there's many, many more business associates in this country than there are covered entities. Just a little side note there. But when we talk about the audits, at least in the older days, 85% of the federal audits have happened against covered entities, but that's certainly going to change, and it is starting to change, and I'll explain why as we move through here. I've also worked as a contracted federal auditor on I don't know, 5 or 6 times, which I don't like doing, but I jump at the opportunity when asked by the Office of Civil Rights to work as a contractor on their behalf to audit groups, because it gives me a better insight into what the federal government's actually looking for when an audit is conducted. So I've seen things from both sides of the coin, and certainly bring that information and that knowledge anytime I do a webinar we're talking about this, to not only make sure that we as an organization are protecting ourselves and protecting the protected health information, but also we are doing what we need to do in the eyes of the federal government. If we get audited, we have the ability to provide them what they're going to ask for in a proactive manner rather than a reactive manner. And lately, in the last few years, and quite frankly, this is the most dangerous aspect to HIPAA, in the last few years I've been working in multiple litigated cases as expert witness, because one of the most dangerous things that happened, and it was very sneaky, not many folks really knew this, but late in 2013, in September of 2013, the federal government put in legislation as part of the HIPAA omnibus rule, basically telling the state's attorney generals to implement laws of remedy, where folks can sue now under state law for wrongful disclosures of their protected health information. And this is certainly changing the game. And to be honest, trial attorneys are far worse to deal with than the federal government has ever been with this law. But the bottom line is this: we have to prove as an organization that we've been proactive with our compliance, regardless if it's an audit that occurs from the federal government or, God forbid, if litigation is brought against us. We have to prove we've been proactive, not reactive. We take the law seriously. We have policies in place. We've assessed risks, and we have mitigated those risks to reasonable and appropriate levels. We've got to be able to do that proactively to protect ourselves. So without further ado, I have quite a few slides here, and I'll try to wrap up at about the hour and 20-minute mark, so you guys have around 10 minutes for Q&A at the end here. A little bit of background, just I'm not going to spend a lot of time on this, but the history of the law. Signed into law in 1996. 21 years old now. It's hard to believe, but it was known as, or is known as, the Health Insurance Portability Act of 1996. Of course, there's been several amendments to it since then, which has made it much more of an enforced law. But it's a very, very robust law. And when we think of HIPAA, most of us think about security of your health record, accessibility of the health record. It's all about the health record. That's just a small part of HIPAA. It's really a very robust law. It was about portability of your health insurance was the main concept. Of course, signed under the Clinton years. This has always been bipartisan. I'm not going to spend much time on this, but always been bipartisan. One of the few things they actually agree on up there. There's been calls from both sides of the aisle for stronger enforcement, especially in the last few years, because historically health care has been terrible, just terrible in terms of leaking of sensitive information, not only from the covered entities, but also from the business associates who work with the covered entities. There's really been no real regulation but HIPAA, which back then, yes, it was on the books, but it really wasn't even being enforced. So a lot of groups just basically swept it under the rug. So Health Insurance Portability and Accountability Act. That's the acronym, the full acronym, Health Insurance Portability and Accountability Act. Two key words missing in that acronym are privacy and